everyone. My name is Giacomo Delledonne. I'm a constitutional law scholar at the Scuola Superiore Sant'Anna in Pisa, and I'm one of the editors of the Sant'Anna Legal Studies project, together with Professor Giuseppe Martinico and Professor Filippo Fontanelli. This is our first webinar after the summer break this year, and we are very happy to host a presentation of a recent monograph by two longtime friends and colleagues, András Jakab and Lando Kirchmair, Saving the European Union from its Illiberal member states. This monograph was published early in 2025 by Oxford University Press within the book series Oxford Studies in European Law. This book presentation event is also part of an Horizon project which we are running at the Scuola Superiore Sant'Anna, the Express 2 project, creating a new EU social contract together. The Sant'Anna, the Scuola Sant'Anna Research Unit is involved in work package 5 on populism, and this is one of the coffee forums in which we aim to discuss fresh ideas and topical issues in European and comparative constitutional law. It's a project in which myself, Professor Martinico, Professor Anna Loretoni, which is in the audience, are involved, with Antonia Battini-Net from the Autonomous University of Barcelona as principal investigator. Couple of words about our speakers this afternoon. First and foremost, the two authors of Saving the European Union from its Illiberal member states. András Jakab is currently a full professor of Austrian constitutional and administrative law at the University of Salzburg, on unpaid leave since 2024, when he took office as judge of the European Court of Human Rights in Strasbourg. András has held a number of research and visiting positions throughout Europe, including in Madrid, in Heidelberg, Budapest, and since 2017 he has been a full professor in Austria. He has written a number of monographs, including on the last one I would like to mention in German. It's an edited volume with him as the main authors on the fundamental principles of the Austrian constitutional order. Lando Kirchmair is currently an Euregio endowed professor for sustainability and mobility law at the University of Innsbruck in Austria. He got a PhD from the University of Salzburg, and until this summer, he was deputy professor for national and international public law with a focus on the protection of cultural heritage at the Department of Social Sciences and Public Affairs of the University of the Bundeswehr in Munich, Germany. He has authored a monograph, many works, including more recently a monograph as sole author on rethinking the relationship between international EU and national law, consent-based monism, published in 2024 by Cambridge University Press. Thank you, András and Lando, for being with us this afternoon. With regard to our two discussants, Antonia Baraggia is a full professor of comparative public law at the University of Milan. She has written extensively, among other things, about rule of law conditionality in the European Union. In 2023, she published a monograph on conditionality as a tool to manage diversity within multi-tier legal systems, with a comparative focus on the United States, Canada, and the European Union. Finally, last but not least, John Morijn, Chair of Law and Politics and International Relations at the University of Groningen in the Netherlands, and member of the Scientific Committee of the Fundamental Rights Agency of the European Union. He has written about populist politics, European political parties, and the protection of Article 2 values in the EU. So I think we have an impressive panel of speakers. And we follow today let's say the house rules. So authors will go first, then they will be followed by the two discussants. So András, you have the floor, 15 minutes. Thank you for being here.
Thank you so much for the invitation. We are really happy and honored that we can talk about our book, and we are also grateful to the two discussants that they will share their thoughts about our book. I will try to share my screen, but first Giuseppe explicitly asked me to show the physical copy of the book, so it already has been published physically recently, and if I manage, I will try to share my screen. Can you see my screen?
Yes.
Excellent. So the title of the book is Saving the European Union from its Illiberal Member States. This book was actually driven by, we have to admit, this book was driven by negative emotions. We had a series of frustrations that was driving us when we wrote this book. Actually, 6 of them, very precisely. And we list all these 6 frustrations in the preface of the book. The first and foremost frustration that we felt when we were dealing with this topic was the feeling that the EU actually lacks effective measures. So there are some measures, but there were in the last 15 years always some excuses why the measures couldn't be taken that could have been taken, actually. So what we have seen were more like half-hearted, smokescreen or postponed measures. And altogether, our impression was that everything that happened was just too little and too late. The second frustration that we had concerned the discourse, which, in our opinion, focused too much on the necessity of new enforcement methods. So it was always the usual thesis was about the lack of new enforcement methods. So therefore, we need some more effective enforcement methods. And in our opinion, that was never really the problem. There were always effective enforcement methods. Of course, you can have new ones, which have even more. But the real problem was a lack of political will to apply them. So if you want the EU to take measures which can help in this situation, then somehow you need to tweak the EU's institutional context. So in a way which incentivizes the actors, the Commission, mainly the Commission, which has a key role, but also other actors at EU level. And this should also happen. This should also happen without a treaty change, because a treaty change is very unlikely to succeed in this situation, because for a treaty change, on the one hand, it takes a long time, and on the other hand, you need unanimity, which by the nature of the problem is unlikely to be achieved. The third frustration that we had was about the framing of the problems, which was both in the academic and in the political discourse. Somehow, the story was explained as if it was some kind of accident. Accidentally bad things happened maybe in Poland and in Hungary, but we just need to sit it out. It will go away, and we shouldn't really be so much worried. We just need to wait. Time is working for us, and we have the opposite opinion or the opposite impression. We think that time is not on our side, and it was not an accident. Actually, what happened is that you had weak cultural immune systems in some EU countries. In many EU member states, you have problems. We think that there are 2 main forces which drive the erosion of the rule of law and democracy. One is polarization. You have that everywhere. And on top of that, in former socialist countries, you also have socialist legacy as a cultural problem. You can measure it. It's not me saying it. You can measure it in the European Social Survey or the World Value Survey. And you can see the differences in attitudes towards judicial independence, fundamental rights, or even towards corruption. You can measure the differences. So you have this socialist legacy, which we call institutional alcoholism. Why we call it institutional alcoholism? We call it institutional alcoholism because it is very similar to alcoholism. So once you have these problems, you try to get out of them, but like an alcoholic, it's easy to slide back unless you have some external help which pushes you into the right direction, and that external help should be the EU. So that was our third frustration. The fourth frustration was that the discourse, in our opinion, focused too much on the search for illiberal legal rules. That somehow you can identify specific rules which make it clear that it is an illiberal regime. We think that misses the point, this kind of search, because the biggest problem in these countries does not concern the legal rules. You do have problems with the legal rules. Some of them are problematic, but really that's the tip of the iceberg. The vast majority of the deterioration of the rule of law and democracy that is in the area of informality. So you have still the same criminal code, but somehow the police or the judiciary begins to apply the same criminal code in a biased way. Also, you still have a constitutional court, you still have a catalog of fundamental rights, but somehow their application in the everyday practice is becoming different. So that's what we describe as still wearing the liberal mask, but actually the gap between written law on the one hand and legal reality on the other hand is growing. So you can also say that one of the key characteristics of the erosion of the rule of law and democracy is that the normativity, the normative force of the legal system is getting weaker and weaker. And unfortunately, that's something that normally lawyers cannot handle so well. We lawyers are trained in analyzing legal rules, but this stepwise weakening of the normative force of the legal system, that's something which we cannot grasp so well. That's why, or that's one of the reasons why we also write about democracy and rule of law indices, because this is a tool to catch, with the help of quantitative methods and basically stemming from political science, these approaches, to catch this type of deterioration. And we think that in this way, we can explain much better how far and how badly the situation is developing, instead of just talking about the legal rules. The fifth point, or the fifth frustration that was driving us concerns the terminology. We were frustrated by the terminology which always talks about rule of law crisis. And we think that if we talk about the rule of law crisis, that only catches half of the problem. As a matter of fact, we have on the one hand the rule of law crisis. By rule of law, we also mean fundamental rights protection. So on the one hand, we have a rule of law crisis, but on the other hand, we have a democracy crisis. And we think that the rule of law and the democracy are mutually supporting each other, or can also mutually deteriorate each other. And if in the discourse we are only focusing on the rule of law crisis, we will not be able to catch the full picture, and also we will not find the right methods to heal these problems. That's why we are using a new terminology. We are talking about an illiberal regime crisis instead of a rule of law crisis. And finally, we were also frustrated by the approach according to which this illiberal regime crisis is only a problem of those countries concerned. So you have some problems in Poland and in Hungary, but actually it doesn't really concern the other countries, and it doesn't concern the EU. And what we think that it does because these countries have very strong negative effects, on the one hand, on the EU itself, and on the other hand, also horizontally, they can influence badly other EU member states. I'm going to get back to this. This is what we call mutual poisoning. So we had lots of negative emotions, but we also tried to be constructive and positive in the sense that we were trying to find antidotes against these mutual poisoning, which can break this bad cycle. So what's this mutual poisoning? Actually, the original title of the book was the European Union and its illiberal member states, and subtitle was Mutual Poisoning and Three Unrelated Antidotes. But the publisher advised us to have a shorter title, and we followed their advice. But the message is still the same. So basically, the key message of this book is this mutual poisoning dynamics. Because usually the picture is that you have the good EU, which is trying to fix some problems in bad member states, but unfortunately it doesn't have the tools. And we think that's not the right way to tell the story, because on the one hand, the EU also caused quite some problems, so there are also negative effects coming from the EU to these countries, the one hand. And on the other hand, also these countries do have very strong negative effects on the EU and also on other member states. So we have a mutual poisoning, and it even strengthens these effects, strengthen each other. So we have some kind of vicious cycle. So what are these negative effects that come from the EU? So how did the EU contribute to the crisis? First of all, the EU did finance these regimes. Second, the EU, the membership in the European Union also meant that emigration was much easier from these countries via free movement of persons, and tens of thousands, hundreds of thousands of young people went to Western Europe, and they were missing in the political processes at home. Just to clarify, I don't say that we shouldn't have free movement of persons, but I say that this was part of the package, and it did have a negative effect on the erosion of the rule of law and democracy in these countries. And finally, and this is probably the most important and probably also the saddest part, we can say that there was also weak and complicit behavior on the side of EU organs. It's partly the Council, but also the European Commission. The question is, why could that happen? And the reason is that once these new EU member states became part of the club, they also got political leverage against the application of norms. So you did have the norms that could have been applied, mainly by the European Commission. But in exchange, it's really like in a way of horse trading that's well documented, also in the book, but elsewhere in the literature. The Commission refrained itself from applying certain norms in order to have some support in totally unrelated topics in the legislative agenda. So overall, we can say that the hope of membership for these former socialist countries was very useful to improve democracy and the rule of law. But once they became member, somehow they could the effects were to a large extent also negative. So the actual membership itself was harmful for the stability of democracy and the rule of law. And we can see that it's not just these two countries, also in other countries, we can see signs of deterioration when you compare that with the period when they only had the hope of membership. So that unfortunately there is this paradoxical situation that the hope was useful, but actual membership was in its actual form harmful. So that's one part of this mutual poisoning. And the other part is how these illiberal member states also poison the EU itself. On the one hand, they can delegate Trojan horse officials in EU institutions, but also in the European Parliament. In the European Parliament, you have today MEPs who have been elected in unfair elections. That obviously poisons the whole institution and the legislative process. The second how these illiberal member states have negative effects is that they can veto measures. It's not just in foreign policy. I mean, you always hear about measures concerning the Ukraine, but also in general, meaningful reforms can be vetoed by them. And third, they also help to erode liberal democracy in other member states horizontally, partly by investments, by corrupt investments into the media in other EU member states, simply by translations of texts or measures that can be also applied in other countries, and by mutual support in international organizations and in EU institutions. So overall, we think that this mutual poisoning dynamics is the key to understand the problem and also to find the methods to counter it. We are not sure how realistic and how quickly a reversal can happen. We are hopeful, and obviously that's the ideal scenario. But what's really necessary as a minimum program is containment. And we think that if we apply the methods that Lando will propose or explain in the next couple of minutes, that at least this containment will be much more likely, and it's much more helpful for the solution of the situation than what has been done so far. So Lando, I pass the word on to you.
Thank you, András. So far, you might have the impression that we are very frustrated and portray a rather negative image. But we also want to be optimistic. We want to contribute with some proposals, what we call antidotes. We have 3 of them, and I will briefly introduce you to all of them, but this will be just sketches. So if you get interested, please ask something in the debate afterwards, or just have a quick look at the chapters dealing with these antidotes. The first antidote we have is about the European Union Justice Scoreboard. We think this is very important because a numerical analysis of the rule of law and democracy in the EU could do some good. It could show us how bad the situation is. And this is very important because this makes it politically more costly not to act. If you have a clear-cut number clearly stating that this and that member state is doing really badly in terms of rule of law and democracy, it's much more difficult to ignore this. And András was talking in our frustrations, or one of our frustrations, about the lack of political will. So we think this could incentivize political will to act. Connected to this is a very important thing, that there is no need to reinvent the wheel here. So there are already existing quite good rule of law indices, democracy indices, and the European Union Justice Scoreboard also already exists. So if the European Union Justice Scoreboard would be improved to represent an actual rule of law index and a democracy index, then this would be already a very good working antidote. So just very briefly here, 2 major things where we think the European Union Justice Scoreboard should be adopted and improved to have this function, to work better in the illiberal regime crisis. First, it should be an actual quantitative index. So bluntly speaking, the current exercise in the Justice Scoreboard, among other things, is counting computers in the judiciary of member states. And computers are necessary to draft judgments, fair, but they're not everything. So it's much more important to know about the independence of a judiciary. And we think that this can only be achieved by including expert opinions in such an exercise. If this would be done, this is just one suggestion, then the European Union Justice Scoreboard would fulfill the purpose we described just before. So another metaphor perhaps might do. Viviane Reding, when she was Commissioner of Justice introducing the Justice Scoreboard, she explicitly said that this should not be a beauty contest. So it's not about ranking member states, showing clearly which member state turns out last, and so on and so forth, which one is perhaps particularly ugly, which one is more beautiful. And we, in contrast, think it precisely should be a beauty contest. It should show us clearly which member state is doing really bad, which one is at the last place, and which one perhaps is doing really well. This is very important. Another aspect which would be adapting the European Justice Scoreboard and improving it would be to simply include the EU as a subject of study. So far, this is not the case. It has been proposed already here and there, but it did not happen. It would be rather easy to do this, and it would be important. It would be important for once because there is the criticism of double standards, saying that the EU is asking from its member states things it's not fulfilling itself. But much more importantly, it would speak to the point András just mentioned before, the mutual poisoning argument. We actually think that there has been considerable deterioration of the rule of law and democracy at EU level also, and there could be even more. And this is just important to know this, to clearly see this development, or perhaps see that it's not that bad at all, but we could only find out if the EU would be within this exercise as well. So this very briefly to our first antidote. I would just straight go to the next antidote, András, if you could put on the next slide. Thank you. The second antidote we propose is completing the Fundamental Rights Union. That's how we call it. First, we think it's very important to strengthen the protection of fundamental rights in all member states. Again, it speaks to our frustrations because fundamental rights protection typically is not dependent on political discretion, but it works differently. And another aspect is that it supports, as András has just said, that the rule of law and democracy in our eyes are interdependent. It would support not only the rule of law, but also democracy. So it would positively influence also democratic culture if the Fundamental Rights Union would be stronger. Now, what do we have in mind here? First, also, the Charter of Fundamental Rights is already there. It is wonderful and it is working well. So this instrument could be used, but we think it should be adapted slightly to work even better in the illiberal regime crisis. How? We think that the Charter must be fully valid at domestic level and applied by national courts in all cases, including those that are purely domestic. So this is an extension, obviously, of the current state, but we think it is a possible one. Currently, Article 51, Part 1 of the Charter is interpreted in a rather narrow sense, one could say, and we, in contrast, suggest a wider interpretation. We think that this key phrase in this article, implementing union law in the current illegal regime crisis, could be understood in a way that also large-scale violations of Article 2 open up and trigger the application of the Charter of Fundamental Rights. Briefly put. So there is more to this argument, and I invite you perhaps to hop on this in the discussion, or just make you more curious about reading this chapter. And for the sake of time, I would just jump to the third antidote, András. The third one is the Spitzenkandidaten system. We think it needs to be further strengthened and stabilized for the long run. So when in 2014 one could argue that it was more or less applied, there was a considerable backlash in the 2019 elections. Still, last year in the EP elections, we could talk of reapplication of the Spitzenkandidaten system. It is a long-standing argument that it would enhance democratic accountability at EU level, which is fine for us. We join in this chorus, but this is not the reason why we bring it up here in the realm of the illiberal regime crisis. We think that the Spitzenkandidaten system has a very important side effect, which could be of importance. And the side effect goes like this. If the Spitzenkandidaten system is applied, the dominant EU organ of electing the president of the European Commission would be the European Parliament instead of the European Council. And if you look at the behavior of these two organs, the European Council and the European Parliament in the last couple of years, in the illiberal regime crisis, we can see that the European Council was more directed towards at least respecting, let's say, respecting the sovereignty of member states, or seeing this as a very important aspect, whereas the European Parliament was much more active and much more eager to actually suggest measures and do something in this illiberal regime crisis. So we think that the Spitzenkandidaten system, if it would be stabilized and applied also in the next elections, it could create an effective institutional incentive for the coherent application of already existing enforcement tools. This speaks again to this point that we think measures are there, but the political will is lacking. And the Spitzenkandidaten system has the important side effect that it incentivizes political action. So we think, in all brevity. And this brings me already to the conclusion and the last slide, András, thank you, which just wants to highlight again that there is an inability of the EU to act in the illiberal regime crisis. And we think that this is also a symptom of its own constitutional malaise. This is what András was talking about in the mutual poisoning argument. So it's not just the good EU who cannot do things, it's also that the EU has been poisoned. And this is part of the story. It's important that this is understood. On our optimistic side, our antidotes, they share common features which are important, we think. So the first one is that they are underrated in the discourse on the illiberal regime crisis. They are not discussed in such a manner, but we thought that this is interesting to describe these proposals because they could be a great improvement. The second aspect is that their implementation is relatively easy. So we do mean by this that there is no treaty change necessary. So these antidotes are not a reflection about a perfectly idealistic new institutional setup. We're not saying that it is not fine to talk about this, but until we get there, these antidotes could be implemented rather easily and could do their job already in the midterm future, perhaps even sooner. The third aspect of these antidotes is, and it speaks again to our argument in the analysis, they address shortcomings at EU level too. So they're improving structurally the EU, and this could contribute to improving, perhaps first containing and then restoring the rule of law and democracy in all member states. Nevertheless, we have to end on a more pessimistic note. Winter is coming. We are convinced that further illiberal regimes in the EU are at least likely, and actions are desperately needed in terms of containing what is going on these days, and especially for restoring. But perhaps we will discuss this later on. Thank you, first of all, for having us, and we are really looking forward to the two comments.
Well, many thanks to both of you, András and Lando. First of all, for sticking so rigorously to the time limits and for providing us with an idea of what your book is about. So the frustration part and the constructive part of your study. So on the one hand, the picture, the gloomy picture, and later what you propose in terms of antidotes. Now, the first discussant will be Professor Antonia Baraggia. Antonia, you have the floor.
Thank you so much, Giacomo. Thank you, the friends of STALS, for this kind invitation. to comment this great book. So it's really a brilliant book that with clarity detach the problems of the rise of illiberal regime in the European Union, and also propose some antidotes to this crisis. I found the chapters of the book very clear in the premises, so the conceptual framework on which the book is based. And I would like to start stressing an aspect that is often overlooked in the debate over the illiberal regime crisis, and which is the role of informal elements beyond the rules. And in the book, it is really clearly explained how the legal culture matters, how informal rules play a pivotal role together with the formal rules. And especially, and this is something that I think sheds light on the path taken by Eastern countries, we need to really take into account the role of socialist cultural legacy in explaining the development of this illiberal trend in Eastern countries. And I also have found the example of the successful path taken by Romania, a brilliant one. So in the book, discussing the role of this institutional building, the example of Romania is brought as an example whether the interplay between formal rules, informal rules, and mechanism introduced by the European Union, the cooperation and verification mechanism, offered a successful path in order to tackle the risk of illiberal regime. Of course, this doesn't mean that Romania is not a risk of further democratic backsliding, but still it has proven to be quite successful. And also I found the statement that paradoxically the EU accession of these countries contributed to erosion of the rule of law and democracy. So very realistic, very grounded. So the enormous amount of money that flowed to this country triggered problems of corruption, mismanagement of funds, and so was a key factor of the erosion of the rule of law in this country. With this regard, I think that the discussion about pre-accession conditionality without a check after the accession is a key point to discuss, also in light of the future accession of new countries like Georgia, Moldova, Western Balkans. So we need really to look at the past examples in order to carefully assess the role of conditionality in post-accession context. Also, I think it's interesting to debate whether Hungary was an exceptional case, and so the authors say no, was not an exception because Hungary took a path that most likely other Eastern countries will take. We have seen recently the constitutional amendment introduced in Slovakia, claiming that was a matter of protecting national identity. So Slovakia is following the path taken by Hungary. And I was also So it was also clear the fact that so the route taken by Hungary was favored by the new constitution that was introduced, and it's also interesting the distinction between the path taken by Poland, which was more detachable in a sense because it was done in violation of the constitutional rules, and differently Hungary established this path of a liberal regime, starting from enacting a new constitution. I also like very much the argument about the mutual interdependence between rule of law and democracy. I think also this is a key point that is clearly discussed in the book. They are linked together. We cannot have rule of law without democracy and vice versa. And often this mutual interdependence has been overlooked. Also, if we think at the rule of law conditionality mechanism, all the debate was dealing with the rule of law issue, not looking at the possible intersection with the protection of democracy. I would like to elaborate a little bit more regarding the role of the Court of Justice, because the role of the Court of Justice is clearly highlighted as one of the drivers of the constitutional structure of the European Union. You mentioned the very first decision that stated the primacy of EU law, and you arrived at discussing the most recent turn of the Court of Justice in protecting the European values, the jurisprudence about Article 2. And to this regard, I have some slightly different views that the one that are addressed in the book, because of course the role of the Court of Justice has been a driving force of EU integration. There is no doubt on this, but I'm wondering whether these values case law, the case law that started with the Portuguese justice on one side, but then was fully elaborated in the two decisions dealing with the conditionality regime, is a desirable path taken by the Court of Justice, because pushing this idea that European values represent the core identity of the European Union, I think maybe trigger even more the reaction of the member states that play the card of national identity, as recently the case of Slovakia showed. So in a context of such polarization, of such confrontation vis-à-vis the European Union, I think that we need to carefully assess the so-called value constitutionalism, and especially dealing with the case law, the jurisprudence of the Court of Justice. And this is related to one of the antidotes that you propose, which is introduce a specific judicial enforcement of the rule of law. And you clearly invoke the application of the European Fundamental Rights Charter whenever a violation of Article 2 in member states provides a ground for fundamental rights violation. In this way, it is quite clear that individuals can counter the erosion of the rule of law on individual basis. But again, I'm wondering whether this proposal through interpretation, to stretching the boundaries of Article 51, would have a too severe, strong impact on the federal balance within the EU. So completing the European fundamental rights will changing completely the federal balance. You will introduce a kind of federal homogeneity clause. And so I'm wondering which is feasible now in this current context, and even if it is desirable to alter dramatically so the federal balance, introducing what can be considered a federal homogeneity clause. And I completely agree with the Spitzencandidate model. So this was one of the big failures of the institutional design within the European Union. So I completely agree with that proposal. What I'm not convinced at 100% is your argument about the fact that the European Union lack enforcement methods. You also in the presentation clearly stated that instead of lacking enforcement methods, there was a lack of political will. And you brought also the example of the application of the rule of law conditionality regime vis-à-vis Poland. So in the change of regime in Poland, the Commission was refrained to apply the conditionality mechanism. But again, I'm wondering whether we should take into account the fact that even in applying the European mechanism, political consideration must have a role. And so, and this is connected also to your first chapter dealing with the role of informal elements. So we cannot just play with rules. We need also to take into consideration political, the political context, political consideration. And on the role of the conditionality regime, I have a slightly different view because I think that before the introduction of the conditionality, the rule of law conditionality, let's call this way the regulation, the European Union was dealing with a context of weak institutional enforcement of the rule of law. There are no still individual enforcement by national courts of the rule of law, and the European has no coercive power because of that federal balance. So I think that there was, at least before the conditionality mechanism, a lack of enforcement methods. Now, so the system of conditionalities dealing with the rule of law conditionality, the RRF conditionality, the charter conditionality, has tried to fill this gap of enforcement. But of course, the application of some of these mechanisms are subject to political discretionality, and I think it's quite unavoidable that a political consideration enter into play in these decisions. And finally, my question is, so how you see the perspective of the new enlargement. So the European Union is dealing with these illiberal trends inside the European Union, but it needs also to look at new countries that are in the path to enter the European Union. So I was wondering whether the proposed mechanism that you clearly advance in your book can be useful also in dealing with the future enlargement. Thank you so much. I stop here.
Thank you, Antonia, for this comment. And now, John Morijn, it's up to you.
Thank you so much, and I'm very glad to see that at least András, even if he has a depressing book, is based is in the sunlight, in the full light of I think it's in Strasbourg. So very happy to see that. I think that my comments are very complementary to those of Antonia Baraggia. So I'm sharing them here. I hope that you can see the slides. Can you confirm that you can see this?
Yeah.
Yep.
Okay, wonderful. So I think that my reflections are going to be about the brilliant problem analysis. In my view, the situation is even worse than was painted, and I have some reflections too on the antidotes that are suggested, which I will be critical of, and I have some antidotes that come into in addition to this that I hope can enrich the discussion. But before I go there, I just want to thank also the authors for the book of thanking me in their preface. Of course, it's always wonderful to work with great talents and wonderful to continue the conversation in this way. So this is to just highlight the extent of the problem. This is a map of the European Union taken from the World Justice Project. And the darker it gets here on this map, the worse the situation is according to this World Justice Project. You see that the problem indeed, and I think that is a really important point of this book, is much, much deeper than thinking that this is only an issue that is regarding Poland and Hungary. This indeed, shows that if we talk about a values enforcement crisis, which I think is indeed the way to think about this, you'll see that there's systematic under-enforcement from the viewpoint of the European Union. And this is also why I would first say that even if the picture that was drawn is already really depressing, it's even more depressing than the 6 bullets that we saw, because I recently wrote a study for the European Parliament that you see here on the slide. And you see that one of the main problems is unequal enforcement of EU law, including values enforcement. One of the things I just highlight one finding here is that 80% of all the preliminary questions that are asked in the area of freedom, security, and justice come from only 20% of the member states. So there's a real unequal enforcement in this field, and this is something that, of course, is mainly due to the European Commission, but also, there's a huge lack of knowledge also in the EU member states, particularly among the judiciary and as well as among the attorneys in these countries, to actually weaponize the EU law to actually protect values in the European Union. So I think that this is an additional problem that we have to factor in. So although I agree very much with the problem analysis, I think that there's problems with each of the 3 antidotes. And I'm telling this, of course, among friends in full admiration of what is being portrayed in this book. But I'm going to go through each of these antidotes first. First, one of the main points that is made in the book is that everything can be done without treaty change. If you to look at Spitzenkandidat wording in Article 17, it really says, and I think that Lando already mentioned this, that the European Council, acting by qualified majority, shall propose the European Parliament a candidate for President of the Commission. So if you really want to make the Spitzenkandidat a reality, I don't think you can do anything else but treaty change. And I can tell you from some experience of having sat in the General Affairs Working Group as a Dutch diplomat for 4 years, I can tell you that the majority of those representatives in the Council and the European Council really see that Spitzenkandidaten is something that requires treaty change. I'm not necessarily for or against it. I don't think that this is the biggest problem in the world, to be honest, in the European Union. But if you want to do this, I don't think that you can deny that this would require treaty change. So this is not something that is easily done. The same I would actually say with this Article 51 Charter argument that Lando was presenting, and sort of said that all you need to do is interpret a little bit more widely Article 51 of the Charter, and then things will be better. The explicit treaty wording that was really, and the Charter wording that was very, very, very central on this political compromise is underlined here. Only when they are implementing union law. Only is a very important word here. So I don't think that if you want to, that you can deny that if you want to widen this, that this would require treaty change. But I have good news on this point as well, because I don't think that this is actually that relevant an issue. Recently, I gave a training on how to apply the Fundamental Rights Charter in strategic litigation. And one of my main points was that if you want to think about charter litigation, you should not really focus on the charter, but on something else. And I compared that to a remora fish. The remora fish is this small little fish that you see here attached to the shark. And lots of people that are thinking about values enforcement focus only on the little fish, the charter. But if you want to really protect values in the European Union, you have to focus on the shark. And the shark is the EU competence. So I think that most problems that András and Lando actually worry about can be dealt with by simply interpreting more widely the EU competences themselves. That's how you can, for example, interpret Article 19 of the Treaty on the European Union more widely as saying that this lays down an obligation on member states to ensure independent courts. You could also argue, for example, based on Article 10, that it's an obligation on member states to organize free and fair elections. So I think that the focus on the Charter in Article 51 is simply really looking at the problem through the wrong side of the telescope, as this is put in Dutch. Of course, the Charter is important, but the most important thing to achieve what András and Lando are actually arguing for is to focus on the big fish and to just look inside the existing competences of the European Union, how these can be interpreted more widely, and then the Charter will follow with that. I don't think that you need to focus on the small fish here, you need to focus on the big fish. Then what is underlying most of this often, and I'm not sure if this is also the case for András and Lando, this could actually be an interesting problem to discuss in the discussion, is that most of the people that argue for Article 51 abolition don't really have a problem with the Charter, but they simply have a problem with the very limiting and limited standing rules for individuals in EU law, which basically says that individuals can only bring cases, as you all know, when they're individually and directly concerned. And here again, it's so essential what I started my talk with, that of course most of the whole system is premised as on guaranteeing a legal protection as a cooperation between national and courts and the European Court of Justice. And that's why it's so essential that 80% of the member states' courts in the European Union very rarely ask preliminary questions in the first place. So I think that that's the hole that we need to plug, and not the Article 51 hole. Then the third remedy, and that is was discussed by Lando, is having a justice scoreboard that is effective. Is this useful? I think perhaps it could be. I also agree that a clearer ranking is probably a good idea, but the whole solution is sort of premised on the assumption that what is really lacking is a lack of data, and that is what is sort of holding back political action. But I think it's not really that. It's really precisely as András said in the beginning. It's a lack of political will to use what we know already, and I think that the solution here is premised on some sort of assumption that what is lacking is data. So I just find this, maybe this is something that could also be clarified by András and Lando. What is precisely lacking here that the justice scoreboard could solve? So these are some of the comments I have on the three antidotes that were suggested by them. But I also wanted to reflect, just for the discussion here, what could be other possible antidotes that are perhaps also, or even more so, well placed to plug the gap that is so importantly identified by these two authors. I have four, and I will talk about each of them very briefly. I think that first of all, what you can do is apply existing legislation and use existing options. I agree with András and Lando that oftentimes in this kind of discussions, we're only talking about new tools and not actually recognizing the potential in existing ones. I think that you could also think of developing new ordinary legislation. Ordinary legislation does not have the same political hurdles, evidently, because you just need qualified majority in the council and a majority in the European Parliament. So there's plenty of ways that you can go in that direction. You don't need the unanimity that you would have for a treaty change. And I just made the point that I think that 2 of the 3 antidotes that were suggested would actually require treaty change. I think a crucial issue could be to discuss whether we should isolate the guardian of the treaties role within the European Commission away from the rest of the political apparatus of the Commission. And I think that Antonia was already talking briefly about this. Should we do more on defending the Court of Justice of the European Union? So I'll talk about each of these for a minute to allow sufficient time. But before I do that, I think that we should realize that each of these options and each of these antidotes and triggering them has become much more difficult due to the central insight that was verbalized by András, in that we have now a problem that has trickled up from the member states. So we have a poisoned European Parliament, we have a poisoned Council and European Council, we have a poisoned Commission. So we should realize that the political EU institutions can no longer fire on all cylinders. So it's whatever you want to do here is going to be very limited because there's simply less political potential for finding a deal here. So what are the existing options? Rule of law conditionality. I agree with Antonia on most of the points that she made. As you see, I also recently wrote an article about this. The regulation on the statute and funding of European political parties, which basically lays down the option that if a European political party or European political foundation in its program or actions contravenes the basic values of the European Union, including all other values apart from the rule of law, either the European Parliament itself in a specific minority or the Commission could trigger a procedure to defund these European political parties. This is basically an Article 7 equivalent for European political parties and foundations. It has never been used and it should be used. And we could do more research on why this is. Article 7, of course, is now also in a different kind of scenario because at the moment only Hungary has this. So we no longer have this scenario where Poland and Hungary could help each other. Perhaps it's Slovakia that has taken the place of Poland in this regard. But I think that there's a new horizon there as well that we should not simply discard. If we look at new legislation, I think that the European Commission has already announced that it will broaden conditionality to all values. We can do research on what, for example, democracy conditionality should look like, or solidarity conditionality, or tolerance, solidarity, each of the values that are laid down in Article 2. This could be changed in legislation simply by a qualified majority in the council. So this is much more promising, in my view, than a unanimity in treaty change. You can think of EU standards for free and fair national and European Union elections. You can think about EU standards for free media. That is much broader than the current European Media Freedom Act. I argued something similar together with Adam Bodnar when he was still the ombudsman of the Republic of Poland in this Politico op-ed from 2021. I think there's plenty of ways to think of new legislation that would be focusing much more in a much more targeted way the kind of problems that András and Lando signal very rightly. I think that the most important debate that we need to have is whether a political independent guardian of the treaties is actually oxymoron. Can you actually be independent as a guardian of the treaties? Well, you are increasingly political. including with regard to the European Parliament. I think it is an oxymoron, and that's why I agree with Dan Caliban and Tom Pavone that just like in the US, at least before it collapsed, that democracy, you could have a discussion about whether that role of guardian of the treaty should be sort of isolated within the European Commission, so that not every decision to start enforcement action is a political decision in the end, and that it should have a sort of an independent rationality. I think that this is absolutely essential to discuss, and this is something that for some reason has not yet really been centrally discussed. But I think that this is something that is absolutely warranted given the kind of scenario that András and Lando were painting. And then very last point, I'm sorry for going a little bit over time. I think we should increasingly ask ourselves, who will defend the Court of Justice and how? Maybe some of you have seen that on the 1st of August, there was a ruling of the Court of Justice, and each of you are insiders, and you know that press releases are always published at 10 o'clock in the morning. And you see here that at less than 2 hours later, the Prime Minister of Italy was extremely critical of what the Court of Justice, the highest court in the European Union, said there. The first word here in her tweet, it's that it's something that is surprising. It's absolutely unheard of. And I'm saying this from Rome. I'm now in Luis. I'm a visiting professor here. That a prime minister of an EU country would call a judgment of the Court of Justice surprising and have a whole populist text here in which in all sorts of ways he criticizes the legitimacy and the authority of the Court of Justice. I think that we should ask ourselves, who's going to defend the Court of Justice and how should this be done? Should this just be done by lawyers? I think that that is a absolutely essential issue that doesn't require new law or new policy, but it does require insight that this is urgent, and it does require skills and energy to put into this. So this is where I wanted to keep my comments. I hope that we can all keep calm and in defending liberal democracy, and I look forward to the discussion.
Well, thank you, John, for these powerful comments, for pointing to contradictions and conundrums in the current stage in the evolution of the integration process. Now we have, let's say, 20 odd minutes for discussion. My plan is, first, we collect questions from the audience. After that, the authors, possibly the discussant, if they wish so, will have some time to react. So first of all, if there are any questions, comments from the audience, so if anyone wishes to break the ice, you can raise your virtual hands. So I see Giuseppe, Ilenia, and Anna Loretoni. Professor Loretoni.
Okay, thank you, Giacomo. Many thanks to the speakers and to the discussants for this very interesting contribution. I'm not a law scholar. My field is political philosophy. And I have a terminological question, a terminological issue, which anyway implies many consequences on the theoretical framework related to the liberal mask or the democratic mask. Anyway, the first point is, in my view, these illiberal regimes, having in mind the Charter of Fundamental Rights and in particular the Chapter 3 of the Charter, in this illiberal regime, we assist not only to a limitation or contraction of political rights, but also to a limitation of civil rights, in particular sexual and reproductive rights. So for understanding this kind of illiberalism, gender issues are extremely important, from US to Hungary, from Poland to Italy. And I would like to understand if this dimension, this point has been explored in your research and your book. This is the first point. The second one is the terminological question. It seems to me that this kind of regime have a democratic mask, because democracy is completely consistent, also can be consistent also with authoritarian regime. On the contrary, is liberalism that is very strongly challenged by this kind of regime. So they have, it seems to me, a democratic mask, but they are totally illiberal, no? And in the traditional philosophical sense, they are against the pluralism, a public space characterized by pluralism, and they are against diversity. And also this dimension have to do with liberalism and much more or less with democracy. Thank you.
Thank you. Giuseppe Martinico.
Thank you. Thanks so much. I mean, I think that this book is a really a powerful message of hope. I think that it combines a strong analytical account of what is going on with some concrete proposals. And so I'm very happy that both András and Lando have immediately accepted our invitation, because this really made my day. I think that we have learned a lot. I mean, thanks to this presentation, and thanks to the comments, of course, I mean, given by Antonia and John. I have just two questions. I mean, first one concerns probably one of the premises that you present in the book. Now, the book attributes much explanatory, I would say, weight to post-socialist legal culture and to informal practices. And I really like that, because it is true. I mean, there is a lot of informality if we look at how they proceed, right? But my question is, might this risk over essentializing Central and Eastern European experiences? I mean, could similar dynamics of informal power and hollowing out of liberal norms be observed in older member states as well? And I think that the answer is positive. I mean, we are witnessing concerning, I mean, dynamics that can be compared to this also in Italy, for instance. So, and this question leads me to my second question, which is more methodological in nature, because I think that your approach is very promising. So my question is, would the author's analytical framework apply beyond the EU? I mean, can this be applied, I mean, to other experiences that don't share, I mean, this post-socialist legal culture? For instance, we are witnessing illiberal dynamics in the US, in Israel, Latin America. Can we use, I mean, this theoretical framework, I mean, to read what is going on also beyond Europe, or is the EU special from this point of view? Thanks so much, and congrats, because I think it's a masterpiece, and I'm sure that we will use it in the future for our research. It's a great book. Thanks so much.
Thank you, Giuseppe. Ilenia Citino.
Thank you very much. Thank you to all the speakers for the very inspiring lecture, and thank you also for the discussions. I was quite impressed by something that said Lando Kirchmair on Spitzenkandidaten, because I wrote a book chapter with Nicola Lupo on the topic in a book published by Palgrave and edited by Thomas Christensen. And I was wondering, you said that the Spitzenkandidaten can be stabilized. And my question is, how do you think that it can be stabilized? And do you think that it is realistic to imagine that the parliament could really be the dominus of the process and, without any treaty change? Well, I had a doubt between both of the position. I would side more with John Morjan, because he says correctly, I think that it requires treaty change and it cannot be done with informal rule. But that's why I was wondering if you thought that there is an alternative to treaty change that can help reinforce this process. Thank you.
Thank you, Ilenia. Wojciech Zomerski, you have the floor.
Thank you very much. Very interesting presentation. Thank you very much. I have two questions. The first question would be, so since you are talking about antidotes, I was thinking in order to find antidote, firstly, we need to know the reasons. And I found it very promising when you started to talk that it's not only rule of law crisis, but also democratic crisis. But then I was slightly surprised that all the antidotes were purely legal, because we have this robust literature these days in social political science, also legal science, which would point very different factors, conditions which made this crisis possible. I would only mention here two. First of all, slightly polemically to what have been said, there is a line of literature which is showing that actually the very accession period light a ground, because it made executive very strong. And I would only mention one name, Anna Meyer-Rose, a wonderful piece. She's comparing the Portugal and Spanish accession and the 2004 accession, and is showing why this 2004 accession was problematic in these terms. And secondly, there's lots of political economics of social inequalities, so on and so forth. So it is possible that these conditions are maybe more important, and then that would be a separate book about the conditions that made this crisis possible. But maybe it's worth to engage with this literature and acknowledge this literature, and then acknowledge that maybe all these legal solutions would have limited effect, because we know that there are other reasons which we would need to address to avoid what has happened in these countries. And then the second question, since it was talked about this socialist legacy, I believe that there is something in this argument of socialist legacy. But then I wonder, is it not a bit of a problem that we take it for granted, and that we should specify what we really mean? Because to echo some of the voices that we had here, that we have illiberal dynamic in all other places, in so-called established, the oldest democracies, such as UK, but most obviously USA. And I think that it's not exaggeration to say that actually the Polish society was fighting law and justice government much more lively than the American society, which is surprisingly passive. So maybe this cultural explanation has also some limitations here, and it has to be problematized in face of this illiberal developments also in established democratic systems. Thank you.
Thank you, Dr. Zomerski. Last but not least, Professor Gábor Holmoly, please.
Thank you very much, and really thank you for both the authors and the commentators. I enjoyed both of them. Let me draw your attention, and maybe this is a question to all of you, to a paradox I detected during the presentations. So while the authors, and especially Lando in his very, very last sentences, emphasized the importance of restoration of liberal democracy in the EU, while, as John rightly observed, these kind of restorations in the imagination of the authors need a lot of treaty changes. On the other hand, it seemed to me that John's proposals, which try to somehow avoid all the required treaty changes, are much more radical changes, in the sense, instead of emphasizing the restoration, he in many respects talking about a transformation of the EU without treaty changes. So what do you think about these alternatives of restoration versus transformation, both the authors and the commentators? Thank you very much.
Thank you. Just a small comment regarding the idea of, let's say, illiberalism within multi-tier, multi-level systems. There is an argument raised by Daniel Kahneman, according to which, on the one hand, there is a peculiar balance of power, federal balance of power within the European Union, which sort of favors the consolidation, the stabilization of illiberal regimes, but also hinders further backsliding. Do you subscribe to this view of this peculiar authoritarian equilibrium, as Kahneman calls it, to the idea that the European Union sort of works as a catalyst, but also as a stabilizing factor in the emergence of illiberal regimes? So I think there are no more raised hands. I give back the floor to András and Lando, who goes first.
Maybe I'll give it a go, and then Lando can answer the rest of the questions. Thank you so much for the two comments and all the questions. I made lots of notes. I don't think I'm gonna be able to reply to all of them, but Lando will have the remaining questions. And I'll begin with a few remarks by Antonia and Joan. It's basically I entirely agree with Antonia that in the case of Romania, the cooperation and verification mechanism is underestimated in the literature. And I think we can admit that much of what we are proposing here in this book as solutions would push the EU towards a more federalized structure. That's I think that's undeniable in our case. And it's true that there are new enforcement mechanisms. There are three different conditions and mechanisms that are being applied nowadays. But the classical and most obvious enforcement mechanism, that's the infringement procedure, where it is well documented, again with numbers, we love numbers. It's well documented that the Commission is actually has been using it less and less. And also it's well documented that in the case of this illiberal regime crisis, there were backdoor deals. It's clear, like if you read any newspaper, it doesn't even need to be like an academic paper. So that's a few remarks I wanted to say connecting to the intervention of Antonia, and then a few remarks connecting to the intervention of Joan. It's the Spitzenkandidaten system. It's obvious that if you had a treaty change, you could introduce it. But our point is that you can also have it without a treaty change. And our example is British constitutional law, where you have so-called constitutional conventions. And constitutional conventions are not legal, like legally obligatory, but they are still an obligation. It's like a political obligation in a wider sense, constitutional obligation, not a strict legal obligation. For example, in British constitutional law, even today, the king could appoint anybody as a prime minister. There is no legal obligation that he appoints a person who commands the majority in the House of Commons as prime minister. Could appoint anybody. But it's just, you shouldn't do that, because otherwise the king will be accused of being of violating the constitution in a wider sense, or at EU level, you could say that it would be anti-democratic or not respecting the results of the election. So the legal rule is one thing, and the other thing is, or the other issue is within the framework of that legal rule, how you apply that. And that's our point. What the Spitzenkandidaten system is becoming, it's step by step, is a constitutional convention in our opinion. So also the last time, and not the one before, but two before, it was applied. And I think Eleni asked us, so how can you stabilize it without a treaty change? Constitutional conventions are stabilized in British constitutional law through usage. So the longer and the more you use it, by time, it will become stronger. So it's not a clear-cut solution. Obviously, ideal would be a treaty change, which is, for obvious reasons, unlikely. But as a second best solution is basically, is something similar. You would, in continental law, you would probably say it's customary law, but it's not really law. It's just some practice which is considered to be the proper way of doing things. And that's our example, basically referring to UK constitutional law. The same is true actually for your remark, John, concerning the Charter of Fundamental Rights. Best thing would be, or one sort of cleanest thing would be to amend Article 51 of the Charter. But we don't think that's very likely to happen, and we think there is potential in the Charter, and we still think that we are within the framework of the legally permissible. So also the Spitzenkandidaten system does not contradict the treaties. Again, we don't think that the application of the Charter also on purely domestic cases would contradict the Charter if there is a doctrinal trigger. The doctrinal trigger is that it needs to be in implementing EU law. And the question is, what could that be? And we say, well, it's actually also Article 2. If Article 2 is being violated, that can be the doctrinal trigger. We recognize this is a wide interpretation of Article 51, but if you have a look at the history of the European Court of Justice, there were quite a few wide interpretations, like when the European Court of Justice introduced the direct effect of the treaties or of directives, or Frankovic. Sometimes it's judicial case law which can introduce novelties. And finally, the EU Justice Scoreboard. Again, this is not something that would solve the situation, but it would help. How could it help the situation? Because it would give additional official arguments which would be clear. Because the discourse currently looks like, yeah, there are serious problems there, and then counter arguments are coming, but well, you also have rule of law problems, I don't know, in Germany or wherever, in Belgium, and you do. But what we need is a clear measure that you have rule of law problems everywhere, but we have different leagues. There are countries where it is much more serious, and there are countries where you have some, but that's not something severe, which really affects the general quality of the rule of law. So again, none of the suggestions that we are saying is the silver bullet. We don't think that there is a silver bullet. We think that there are like small steps which can help in the situation. And again, we don't say that's all the possibilities. We are very much aware that there are also other options or other methods, and you listed a few of them. And then we don't deny that they can be helpful. Oh, sorry, we don't deny that they are contributing to the solution of the situation. But we think that these three methods that we are suggesting, they are underrated or under-discussed in the literature, and they somehow capture the nature of the problem, this incentivization problem. Other methods are possible. Again, I mean, the problems are even though a little bit similar, I can mirror your remarks, which are entirely justified. I mean, if you want to change the system of MEP elections, or if you want to like have stricter standards there, or meddle with the legal basis, then again you have the problem that some of it is not in the treaty. It's in secondary legislation in the Electoral Act 1976, but there you need unanimity in the council. So that again, that's not so simple to get in this situation. And again, if you say that within the Commission we should have an independent enforcement agency, if I understand the suggestion correctly, that's a legitimate suggestion. I'm just wondering, how much it is really a guarantee. I mean, how much it's likely to happen, first of all. But even if it's happening, how much you really have a guarantee if it's not in the treaties? And you can say, well, that's why you need some democratic practices, but this is exactly what we propose with the Spitzenkandidaten system. And finally, maybe one more remark. We had a question concerning the ideological nature of these illiberal regimes, and the picture is mixed. It's not very clear. I mean, some illiberal regimes are more ideological; they actually mean what they are saying, and others are only using ideological cleavages for purposeful polarization in order to, drive the political discourse. It's a mixed picture. And I had the very last one, Giuseppe, whether or how it can be used, what we are saying elsewhere in the world. I think one key message that we are making in this volume is that lawyers in general are, understandably, including myself, very much focused on formal legal acts. But nowadays, when we talk about the erosion of the rule of law and democracy, it's really just the tip of the iceberg. And we have to admit that we have difficulties to catch that. And that's one of the reasons why we began dealing with rule of law indices and democracy indices many years ago, is that we have to admit that as lawyers, we are not equipped to capture, this type of erosion, where it is not so much in formal legal acts. So that would be one message that could be taken elsewhere. And there are definitely a few more points which I haven't replied, but I also want to leave some room to Lando.
Well, first of all, also from my side, thank you very much for wonderful comments and also many very interesting questions. I also took notes, and this inspires for a further debate. So I won't be in the position to answer all of them in full detail here. I think also the time has passed already, but let me just maybe pick up some of them. Something András mentioned in the end is that the informality aspect is very important, especially for lawyers, because we're trained not to look at it that closely. This is something which could be used also from our analytical framework for looking at other places except Europe. So informal aspects can play an important role, and looking more at them could perhaps also help understand situations better in other countries, even though there is no post-socialist legacy. But I think it's fair to say that we're not saying in this book that it's just the post-socialist legal culture which is the problem. It is a big part of the problem in Europe. But this does not mean that everywhere else, if you don't have this legacy, you're free of problems. And it doesn't also not mean in Europe, if you can deal with it, then you won't have problems anymore in Eastern Europe. It's just part of it. Polarization, for instance, would be another important aspect. Then going on, I'm just hopping through the different points here. Talking about lawyers, perhaps we did somehow good in the analysis of looking beyond our legal educational background, but when proposing antidotes, we in a way have to admit that we are still lawyers. So what we're trying to do is to talk about doctrinal legal solutions. Perhaps some of them are argued in a way which is a little bit challenging for some lawyers, but still we think we can say that we're in the doctrinal realm. We argue in terms of how you could interpret the law and use the law, because I think this is an important part of the puzzle, but this is not everything. So complementary literature, also for lawyers, very important and very welcome, and for sure also an important part of the puzzle. But our competence is still the law, so that's perhaps the reason why we stick to it in the antidotes. Quickly talking about the question and the paradox, whether we talk about restoration or transformation. I don't know if it's so easy to clearly draw a line here. So parts of our antidotes perhaps could also lead to a transformation, but in the midterm future, perhaps. Now, if some of the antidotes we propose are established and work well, this could also transform the EU and could not only lead to restoration of the rule of law. Perhaps other measures would only lead to restoration. So I'd say for us, this, at least that's, I think it's fair to say, for us, this wasn't the most important driver in writing or thinking about the antidotes. It wasn't about thinking of a completely new institutional setup, but more towards what are currently working potential issues which are somehow easily implementable. But it's fair to say that they are discussable. It's not that it's a very easy fix. So we need to argue and discuss all of them. So I will just pick up one discussion which was mentioned by Antonia about the national identity. So if you are too keen in arguing for improving, advancing the situation, perhaps if we ask too much from the ECJ in interpreting the charter in one of our antidotes, this could trigger even more member state court to talk about or strengthen national identity. But I'd say there's one first important thing to point out here is that the whole figure of constitutional identity is in Article 4 of the treaty, but I think it's fair to say that it's meant in a very different way, and at least would be still in the authority of interpretation of the ECJ, how it was meant there, and it became a very different judicial creature, one could say, which could also be very much debated whether this is actually in the law of the member states and in all of these constitutions, or whether this is something member state courts came up with. So what I would try to emphasize here is that at least what we had in mind with our antidotes is that they strengthen also rule of law and democracy at EU level. And doing so actually first criticizes the EU for not being really on top of rule of law and democracy standards here, which could also contribute to the aspect that this critique coming from member states, if you take it seriously, is in a way at least spoken to by improving also standards at EU level. This is one important thing. And another important thing is that the question whether too keen of a move by the ECJ, for instance, could trigger even stronger delegitimization of the EU in some of its member states. I don't know, but I think in some member states, it's not so important what the ECJ is actually deciding. There is anyhow some criticism and delegitimizing of the EU. And on the other hand, you have citizens in these member states who perhaps could also have a slightly less positive impression of the EU if they have the feeling that they're left alone with their illiberal regimes, and if the EU is not doing enough here. So perhaps I would end on an optimistic note, saying that we could be more self-confident of offering antidotes without having to be too much afraid that these antidotes could do worse, or would even be worse than not doing anything. So this is me trying to be a little bit optimistic, and once again thank you big time for wonderful inputs and comments.
Thank you, András. Thank you, Lando. Now it's 7:10, 7:12. So I think we are exhausting our time. I would like to thank you all, our authors, our discussants, Antonia, Baraggia, and Morijn, those who raised the comments during the discussion. It has been a great book launch. So both Giuseppe and myself are grateful for this enriching discussion today. So see you next time for the next TALS webinar. And once again, many thanks to all of you.